So, what is the object of this 33? As I mentioned that the poverty should not be the cause for refusal of justice. So, therefore, the court fee could be exempted if he is suffering from or if he is inefficient to make the payment of court fee. Now, coming to the consequential things. So, at the time of presentation of a case, he is declared as indigent. Now, we are at the end of the litigation. At the end, the court declares that indigent person as a successful litigant. He wins the case. Then what happens? The consequences are quite surprising. The moment a person is declared as winner or who succeeds in the case, the benefit that he is drawing from the case, on that benefit the court creates its court fee as a first charge in the sense that the court will satisfy its fees first, the remaining amount would be given to the indigent person. So, this is what happens if he is successful. So, he will not be getting the full benefit of the litigation, he would be getting the benefits minus the court fee. What happens if he is unsuccessful? At the end of the litigation he loses the case. Then the court would ask the state to take all the steps to recover the court fee from the remaining assets of the indigent person. Now, why do they do that? Why do they recover even if the client is unsuccessful? That is something which we need to think about and talk about. Is it because the court or the legislatures fear about unnecessary frivolous litigations only because he is exempted from paying court fee? If that is the case, then most of the poor people will harass the other part of the society by filing frivolous litigations. That may be the reason, or else what? That is left to our own thinking, as the legislatures did not clarify this situation. But as far as I am concerned, I feel court fee payment by an unsuccessful indigent litigant, the reason may be only this: to discourage unnecessary and frivolous litigations. So, what is the final effect of CPC on indigent person? As mentioned by a court in R.V. Dey versus Chief Secretary Government of Kerala, the payment of court fee as a scheme, that is under Order 33 and 44, suggests is that payment of court fee is merely deferred, it is not wiped off. So, similarly, the court said that the court fee, payment of court fee at the initial stage is exempted. It is not exempted altogether, but only at the initial stage it is exempted. So, from poor accessing justice, now let us move on to a person who cannot afford time, and for him the CPC is been amended in the year 2002 and they brought ADRS, Alternative Dispute Resolution Systems, as a means of access to justice. So, here the 2002 amendment inserted section 89, and this insertion led to additional proceedings before filing of a suit. Now, what is the additional procedure? It goes like this: a judge, before taking up a case, he looks into the nature of a dispute, and if he finds that there is an element of settlement in the dispute and which is acceptable for both the parties, the judge would formulate a probable settlement and send it to the parties, their advocates, for their comments. And after sending this probable settlement to the parties for their comments, If the possibility of settlement brightens up, he would refer it to mediation, negotiation, arbitration, or legal lok adalat, depending upon the party's choice. This process has been criticized by Justice Ravindran in one of his judgment. Before that, he had written an article also criticizing this process, and I find there is a sort of merit in the criticism, and that is, how can a judge draft a possible settlement without hearing the parties? So, the procedure which has been mentioned by the section 89 should be postponed to the mediators negotiators after the referral of a dispute. Speedy and state. Now, if you look at this, whenever any person is aggrieved by the action of a state, the party have a right to file a case against the state, but before doing so they have to follow a certain procedure. The procedure is issuance of notice. Before filing a case, a suit against the state, they have to provide a notice of 2 months duration. Why the special procedure? Why 2 months is given to the state? The object behind this is again ADRS. The legislatures feel that the executive should be given an opportunity to settle the dispute outside the court before it gets into status of a litigation. So, therefore, here the 2 months duration would be utilized by the public officer or the department to find out the actual violation of a right and try to compensate for the violation or try to reason out with the party aggrieved by the violation and try to settle it outside the court. So, then comes the next, again a speedy process to resolve a dispute, that is compromise decree. Now, here again ADRS is being encouraged by the court, where the suit is pending in the court and the parties negotiate outside the court, settle the dispute outside the court, or the part of the dispute is adjusted outside the court. Immediately such adjustment, such settlement would be converted into a compromise decree by the court. This is again a case of encouragement for speedy disposal of a case. So, therefore, what I draw from this process, this discussion is that access to justice by poor, by exempting court fee, provision is there in CPC. Access to justice by poor in the form of speedy justice is also present in CPC, and it is present in a sufficient manner.